Hello, everyone. It's my great pleasure to host the panel about controlling owners, which is a topic that in recent years have provided an ample of doctrinal change. But first, let me introduce the members of the panel. We have a wonderful panel, and I'll go by the order in which they sit. Justice Jake Jacobs served on the Delaware Supreme Court from 2003 to 2014, and prior to that as the Vice Chancellor of Delaware Court of Chancery from 1985. Among the many landmark cases he wrote, cases I teach in my class, as many of my students here know, are Walt Disney, Gantler, and Toll Brothers. Currently, Justice Jacobs is an adjunct professor of law at NYU, Columbia, Vanderbilt, and Penn Law Schools. He is the member of the American Law Institute, having served as an advisor to the Restatement Third of Restitution Project, and is currently involved in its Principles of the Law project. Justice Jacobs is also a member of the Delaware and American Bar Association, a fellow of the American Bar Foundation, and advisory board member of the RAND Center for Corporate Ethics and Governance. Justice Jacobs was recognized in the years 2016 to 2019 editions of the Best Lawyers in America for his exceptional contributions to the legal field. Next, Daniel Slifkin is a partner in Cravat's litigation department and served as head of the department from 2016 to 2021. With over 30 years at the firm, Daniel has tried numerous high-stakes business-critical cases in state and federal courts, as well as in domestic and international arbitrations. Notably, he is among the rare litigators to have taken a securities fraud class action to a jury verdict. Among his recent prominent cases, Daniel was part of the team presenting Elon Musk and members of the Tesla board of directors in two significant matters: the Tesla securities litigation, which challenged Tesla's acquisition of SolarCity, and Tornetta versus Musk, which contested Elon Musk's 2018 compensation package. In the SolarCity case, the transaction was deemed entirely fair in a post-trial judgment, while the compensation package was found not to be entirely fair, a matter still awaiting final judgment in the Delaware Chancery Court. Ann Lipton is the Michael M. Fleshman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of the Tulane's Murphy Institute. A leading scholar in corporate and securities law, she has published numerous impactful articles, including works on Delaware doctrine governing controlling owners. Before joining the Tulane faculty, Professor Lipton practiced in New York as a plaintiff-side securities class action litigator at several prominent firms, including Bernstein, Litowitz, Berger, and Grossmann. Stephen Fraidin is widely regarded as one of the world's leading M&A lawyers, having played a pivotal role in many landmark transactions since graduating from Yale Law School in 1964. His legendary cases include the iconic RJR Nabisco deal featured in Barbarians at the Gate, the dramatic events of the Revlon saga, and numerous transactional innovations such as the development of the top-up options. For over 30 years, he has taught the Advanced Corporate Law course at Yale Law School, a class I took as a student in 1990, and he is now co-teaching it with me at Columbia Law School. Over his distinguished career, he has been a partner at Fried Frank and Kirkland & Ellis, and currently he is a partner at Cadwalader, Wickersham, and Taft. Mark Lebovitch is a lecturer in law at Columbia Law School, where he co-teaches the new course Legal Financial Arbitrage, and an adjunct professor at the University of Pennsylvania Law School, co-teaching advanced topics in corporate law. He also serves on the board of a non-profit organization dedicated to combating anti-Semitism in America. Before retiring from legal practice in September, Mark spent nearly 25 years focusing on corporate governance, including 19 years as a plaintiff-side attorney. During that time, he founded and led the governance practice at Bernstein, Litowitz, Berger, and Grossmann. Thank you so much for joining us. And I will give each member of the panel a few minutes to present their point of view on the issue of controlling owners. Hopefully, once we collect all those viewpoints, I can follow up with questions, and then if time left, to open it to the audience. Let me start with Justice Jacobs with an overview of Delaware regulation regarding controlling owners.
Thank you, Zohar. Can everyone hear me? It's an honor to be included among these very distinguished panelists. I have a point of view, but I'm not going to present it. I'm here because my job is to set the stage. That is to provide a roadmap of the controlling stockholder problem and attempt to explain why, after so many decades of Delaware corporate jurisprudence, it is still a problem, and to identify the issues that the problem is currently generating. What I have to say is easily summarized in 3 separate points. Point number 1, the controlling stockholder problem has continued to be a problem because it is driven by the legal risks and the economic costs of entire fairness judicial review. Now, this should not come as a surprise to any of you. For corporate officers and directors, entire fairness review creates the highest liability risk for corporate fiduciaries because it imposes on them the burden of proving that the transaction at issue is fair, entirely fair, both as to process and price. Exacerbating that liability risk was that typically these cases were brought as class actions. Notably, in a few cases, the fiduciaries did meet that burden, but in most cases they didn't, and as a result, cases decided after Weinberger in 1983 were mostly settled, irrespective of whatever their merit may have been. Now, separate and apart from liability is the extraordinary cost of litigating an entire fairness case. Before MFW was decided in 2014, it was virtually impossible to get an entire fairness case dismissed on the pleadings. And that inevitably led to time-consuming and highly expensive discovery, after which the only options for the defense side were either a summary judgment motion or a trial on the merits. Because a summary judgment motion was very hard to win, most cases went to trial, further multiplying the expense. So it's not a great wonder that most, if not all, entire fairness cases were settled before discovery, vindicating the fiduciaries in court was viewed to be simply not worth the risk or the cost. Point 2, these realities resulted in efforts to create workarounds to avoid or at least mitigate entire fairness review. In its seminal Weinberger decision, the Delaware Supreme Court reassured corporate fiduciaries that entire fairness review could be mitigated, not avoided, if the transaction were made subject to either approval by a committee of independent directors or by approval of unaffiliated minority stockholders. Either mechanism would shift the burden to the plaintiff to prove unfairness. That was the theory. In practice, however, this reassurance was of minimal use for 3 reasons. Number 1, only after trial would the defendants even know if they had earned a burden shift. Next, most controllers were unwilling to give institutional investors a veto power over their transaction, which meant that the only cleansing route that was chosen was the independent committee route. And thirdly, the independence of the independent committee invariably became another costly and unpredictable litigation issue. So from a practical standpoint, fiduciaries still remain subject to the liability risk and litigation expense of entire fairness review. Further compounding the problem was the Supreme Court's recent match decision, which, although it expanded the protection of MFW to cover transactions other than freeze-out mergers, it made the protection harder to obtain by requiring that all, not just a majority of the members of the committee, be independent. So as a result, the corporate bar has still been searching for workarounds. One notable effort was to advocate that entire fairness review should not apply where the transaction is subject both to special committee and independent shareholder approval. It's a great argument, but it took 30 years for that argument to meet with favor by the Delaware courts in MFW. A primary reason which continues to haunt us today is that the Delaware courts viewed the presence of a controlling stockholder as inherently coercive, such that even an independent committee could not be presumed to, an independent committee that approves a transaction couldn't be presumed to have exercised or made an uninfluenced, unbiased business judgment. So, although on paper MFW looked great, in practice it wasn't, because all of the critical conditions for MFW to apply ended up being the subject of litigation. The latest iteration of a workaround, which explains why we are having this conference and this panel, has led to an entirely new conceptual approach. And that is, since there is no viable or economically satisfactory or practically certain way to avoid fairness review, then let's take the position that entire fairness does not apply at all. How do we get there? We get there by arguing that in each particular case, the essential precondition of entire fairness review, a controlling stockholder, did not in law or in fact actually control the corporation either generally or the transaction at issue specifically. It is that paradigm shift that brings us full circle to the universe of newly litigated controller issues that we on this panel are being asked to address. And that leads me to my final point, number 3, which is, well, what are these issues? Just to start with the basic legal principle, there are only 2 ways for a stockholder to be a controller. You either own 1 share above 50%, and that's easy. All you need to know how to do is count. Or if you don't have an absolute majority, then you have to be found to have soft control, quote, which is actual control over the corporation's business affairs. Now, the problem, of course, where the rubber meets the road is soft control, because each soft control claim involves a fact-intensive, case-specific litigation. And unsurprisingly, the case law on this issue are all over the place. Back in 2021, I had occasion to review an internal firm memo which showed that 3.5 years ago, there were 17 Delaware decisions that found soft control and 15 that didn't. That was 3.5 years ago. Experience since then has shown that the number of those cases going both ways has multiplied. Time doesn't permit me to get to discuss these issues, but it does, and I think what I will do is close by identifying 3 what I call meta issues. The first is a major hobgoblin underlying the controversy over what constitutes actual or soft control is this doctrine of inherent coercion, which the Supreme Court validated back in 1994 in Conn v. Lynch. The issue, as I pose it, is whether it makes sense to retain this doctrine or whether it should now be exercised out of Delaware fiduciary duty law altogether. The second issue is whether, if inherent control continues to have vitality, it should be recognized to exist where there is only potential soft control, that is the ability to exercise control, but not the actual exercise with respect to the transaction being litigated. That is a critical issue before the Delaware Supreme Court today in the Oracle case, and hopefully we'll hear from them about that. So I will conclude on that point.
Thank you so much. Daniel, would you like to expand on the definition of a controlling owner?
Sure. And we put together some slides which might help with the conversation. Are those up yet? Okay. Okay, so what I'd like to do is just spend a few minutes talking generally about this definition of controller, which Justice Jacobs and Vice Chancellor Will touched on just a few minutes ago. And then I want to talk about my client, Elon Musk. And in particular, the two cases that we tried for him, Solar City and then Tornetta, which is still ongoing, so I'm going to be a little bit circumspect there. So one might think that the standard for controlling shareholders should be very clear. It's like, do you have a majority of votes? Do you have more than 50%? But the law has evolved to say, well, no, we think there are folks who can control a corporation practically, even if they don't have 50%. And so the test has become, do they exercise formidable voting and managerial power as if they had majority voting control? The other articulation in the case is does the controller, does the entity have the ability to dominate the corporate decision-making process? And the cases have come up with a bunch of indicia, a bunch of facts that they look for to determine whether or not there's control. Some of these, there's the issue of significant equity stake, but significant is undefined, as whether is it 5%, 10%, 15%, 20%, we don't know. Some of these are hard, some of these are, and that's clear. Maybe you have contractual rights such that you can make other people vote your way and it gets over 50%. That's pretty easy. Maybe you have the right to appoint directors. Maybe there's clear threats of retribution against people. But some of these are very, very soft. Like, do you have outsized influence? Do you dominate board discussions? One might say, well, look, any CEO of any public company in America has a significant shareholding. Almost certainly they got a lot of stock options, and they exercise day-to-day managerial control, and they probably are quite influential at the board level, because most boards, support their CEO and don't willy-nilly tell them no. But that can't possibly be the test for control, because then every CEO is a controller, and we know that's not right. So given that this can be both general and specific, and most of these cases are about was there control in the specific context, the way I see it, the way I'd like to see it is, was the board and the shareholder browbeaten into doing something they didn't otherwise want to do and wouldn't otherwise have done it by the CEO? So let's talk a little bit about Elon. Okay. So back in 2016, and I'm going to summarize this in a very succinct fashion and not go into the detail. Back in 2016, Tesla bought Solar City. Tesla was regarded as a car company. Solar City is regarded as a solar power company. For those who don't know, when Elon sold his interest in PayPal, he took the money and invested it into three companies: Tesla, the car company; SpaceX, the rocket company; and Solar City, which put solar panels on people's homes. And Solar City was run for him by his cousins, Lyndon and Peter Rives. Footnote, when we were litigating this case, pre-trial, Laurie Will was the lawyer for Solar City and Lyndon and Peter Rives, so that's how I know her. Okay, 2016, Elon buys his other company, has Tesla, one of his companies, buy Solar City, one of his other companies run by his cousins. That deal looks very odd to a lot of market commentators. People are saying, why did a car company buy a solar power company? But the issue in order to get entire fairness review is, was he a controlling shareholder? The court let that go on motion to dismiss because there was lots of pleading of these other factors. In the post-trial opinion, there was no finding that Musk controlled Tesla. And it was pretty clear from the post-trial opinion that the board was not browbeaten into this decision. It was part of the overall corporate strategy, which many people could second guess, right? Ex ante. Ex post is very difficult to second guess Elon Musk's corporate strategy. My one regret about doing these cases for Elon Musk is it precluded me from buying Tesla stock, right? And on appeal, the Delaware Supreme Court said, we say for another day whether a stockholder with 22% of the voting power, but who may exercise managerial supremacy, is a controlling stockholder. So here we had the very unusual circumstance of complete and total entire fairness review with no finding of there being a controlling shareholder at all. And just to echo something that Justice Jacob mentioned, given the stakes at issue, all of the directors other than Elon settled out prior to trial with money from insurance policies. Elon, A, he doesn't settle. B, he has more money than most other people. So, okay, so then let's talk about Tornetta. Unlike Solar City, I would say at first blush, Tornetta doesn't raise automatic sort of red flags. Because this was a pay package which was entirely performance-based. If he didn't bring fantastic results, he wouldn't get any money at all. And in fact, for the first couple of years after 2018, Elon worked like a dog and slept on the factory floor and didn't hit any of the milestones and didn't get paid anything. It's 1% of stock for every $50 billion increase in market cap, right? This is a company that when this was put in place was worth less than 60 billion. And that's one raw percentage point. Basically, on a fully diluted basis, it's 6% for $600 billion worth of increase in market cap, which ab initio, I think I'd do that deal. Post-trial opinion, the court found that Musk did control the process that resulted in the 2018 plan. He had enormous influence. He had almost 22% of the company. He was absolutely a superstar. He'd been the chair. He was the CEO. He was the founder. He had lots of ties with the directors. They all knew each other very well, and they'd been working together a long time. And the court said, well, he really drove the process by which his own compensation package was agreed to. But let me first of all point out some of the things that the court didn't find, and then give a few observations of my own. There's no evidence that there was any wielding of power to control the vote. The court didn't allude to the inherent coercion doctrine, but the inherent coercion doctrine is kind of strange, given that the shareholder vote here with people like Vanguard and T. Rowe Price and Barron Funds and like people who are very sophisticated with a lot of money. Tesla, I believe, was the most widely held stock in America. There was no finding that he had coercive contractual rights. He couldn't appoint directors. He couldn't determine their compensation. There was no finding that a majority of the 6 relevant directors who approved the package were conflicted. There was no evidence of threats of retribution. And any findings that he's dominated the process were in the context of negotiation of his own personal package, his own pay package. So let me offer some observations here. I think these control tests that the courts have developed, in particular in the compensation context, are extremely difficult to apply, because the power here comes from the shareholders' ability to withdraw their labor if they're not satisfied with the terms of their pay package. But we all have that power, right? We can all say, I don't like that, I'm going to go work somewhere else. The board is controlled only to the extent that it wants to retain that labor, right? Negotiations over executive comp are highly unlikely to be adversarial in nature because you want to keep the guy happy, right? The board plainly wanted to retain and incentivize Musk, so he would focus his attentions on Tesla, right? Because we all know that he has some other business interests and interests beyond business, apparently, today as well. And the evidence was clear that everybody thought that Musk was absolutely a critical employee and uniquely instrumental at a pivotal time in the company's development. So there really was no evidence that people were browbeaten into giving this package to him that he wouldn't otherwise take. There was a Wall Street Journal op-ed piece which basically said that they thought the job of the board should have been to figure out what he wanted and give it to him in order to keep him happy, which is exactly what they did. And here we have the unusual circumstance of having gone through this trial and applied Delaware law. We have a $1 trillion increase in shareholder value and finding a breach of fiduciary duty.
Thank you. And would you like to discuss the purposes for which we use the definition of a controlling owner?
Yeah, so I have this spiel. Some of you may have heard my spiel, but I'm going to do my spiel because not everyone has heard my spiel. So under Delaware law, if you have control, hard control, 50%, there are 3 legal consequences, or 2.5, depending on how you count. 1, controlling shareholders have a fiduciary duty to the minority. So normally if you're a contractual counterparty or a minority shareholder, you have no fiduciary duty to the company. You can deal with the company, and if you can get a great deal out of them and even exploit them, if you can manage it, more power to you. But if you are a controlling shareholder, that is not permitted. You have a fiduciary duty to the company. Second, controlling shareholders are subject to this unique cleansing regime, the MFW double trigger regime. And third, control, it's sometimes treated as something that has independent financial value. So directors may violate their fiduciary obligations if they transfer control to from shareholders to someone else without giving them without taking proper consideration. And the loss of control that way for shareholders gives rise to a direct rather than a derivative claim. So that last point is kind of complicated, but we know the rule used to be that if you're a company with a controlling shareholder and the company sold to the controller additional stock on the cheap, that would give rise to both a direct and a derivative claim, and the Delaware Supreme Court overruled that in Brookfield. But at the same time, Brookfield had this interesting dicta that suggests if a share sale or corporate action hands control to someone who didn't have it before, went from 40% to 60%, then that would give rise to a direct claim because shareholders are losing out on the premium they might have gotten at a later point. And they even suggested that if you, say, have a 2/3 charter provision that can only be met with 2/3, and you do something that takes someone from 55% to over 2/3, that too could give rise to a direct claim because there's a loss of control right to the minority shareholders. So that was dicta in Brookfield, but some Delaware cases since then have sort of followed that logic. So that's a third issue that comes up when we're talking about transfers of control, whether there's a value that's taken from the minority shareholders and whether it gives rise to a direct or derivative claim. So we have these 3 issues: fiduciary duties, special cleansing, and direct derivative distinction. Now, as we've been talking about, one issue that keeps coming up in Delaware is who is a controller. And that's easy if it's 50% of the vote. If it's less than 50% of the vote, we have all these factors, and I think that is wrong. It's wrong. It's the wrong way to go about analyzing it. My argument is, if we're trying to determine whether someone is a controller, we need to ask why we're asking the question. Because the test for whether they have control or not should be different depending on whether we're trying to ask about fiduciary obligation or whether we're trying to ask about cleansing or another issue. So an example, Oracle, pending before the Delaware Supreme Court right now. There's this conflicted transaction with Larry Ellison, who had less than 30% of the vote, and the plaintiffs claimed he was a controller. The Chancery Court said he wasn't a controller, so that's on appeal. But why are they saying he's a controller? Are they asking whether he had fiduciary duties? They are not asking whether he had fiduciary duties. He absolutely had fiduciary duties because he was a director of the company and an officer of the company. The only thing they're asking is whether or not there needs to be cleansing, the MFW cleansing. But that's not true in other cases. So a lot of these cases are actually not cleansing cases at all. They're cases where somebody had some kind of bespoke contractual rights to block transactions, and the question was whether they had to exercise fiduciary obligations when they dealt with those rights. It wasn't about cleansing at all. Completely different questions. So my point is these are different questions, and therefore I think the test for how we resolve them should be different. And so what I think the world should look like is, if we're asking, does someone have fiduciary obligations, the test should be, do they have control over the assets of others? That's very similar to the traditional test that we've been applying all along, but I think it gets kind of complicated when you're talking about control rights that come from some kind of contractual relationship, because we don't normally say exercising your contractual rights give rise to fiduciary obligations. My theory is that sometimes contractual rights are used to manipulate the company in unexpected ways, and that's the kind of thing that would give rise to a fiduciary obligation, because it wasn't the contractual right that people understood that you had at the time of contracting. But what if the question isn't whether you have fiduciary duties? What if we know they have fiduciary duties, like Elon Musk, who certainly has fiduciary duties in some capacity, but we're only asking if they need MFW cleansing procedures? And to me, we get back to first principles and we ask, why do we have MFW cleansing procedures? The answer is, as we said before, inherent coercion. Controlling shareholders are scary because they can retaliate against directors and they can retaliate against minority shareholders who can buck the controller's will. But that's not the complete answer, because directors can retaliate. Like if directors ask for a cleansing on a normal director-interested transaction, directors could retaliate if shareholders, say, refuse to cleanse. So there's another piece, entrenchment. If directors retaliate, like shareholders, they ask shareholders to approve their compensation, shareholders vote it down, and directors say, well, that's it, I'm not paying dividends to the shareholders anymore. There's a solution to that. The shareholders can vote them out. So controlling shareholders, the hard control, they're scary because they not only can retaliate, but because they're entrenched. You can't get rid of them. Now, if that's right, now we know what to look for when we need MFW cleansing. We should look for retaliatory capabilities in someone who is entrenched, someone who is relatively immune from the market for corporate control. That's what we look to when the only issue on the table is cleansing. And then finally, this lingering question, it has to do with whether there's been a transfer of control rights that can be challenged directly rather than derivatively. And I think that's going to depend on whether the control that's being transferred functionally reduced the kind of premium that shareholders would have gotten in some kind of later deal. And yeah, that's basically my theory.
Thank you, Anne. Stephen, would you like to discuss your view on the cleansing mechanism?
Yeah, look, the issue of how to deal with controlled companies and controlling shareholders has been a persistent issue in Delaware law, and that's for good reason, because investors have a right to expect that when they invest in a company, a controlling shareholder is not going to take advantage of the situation and, for example, deprive them of their stock in a freeze-out transaction at a price designated by the controlling shareholder. And a lot of the law in this area was developed to deal with exactly that kind of issue, freeze-out transactions. But there's really three issues that have caused this particular subject to be a persistent and difficult to deal with problem. The first is, what is a controlled company? You've heard some discussion here about whether Tesla is a controlled company. You've heard discussion about other situations, and I think the reason for the difficulty is that while it is possible to formulate, it's easy to formulate a rule that says ownership of a certain percentage of stock that isn't controlled by a governance agreement makes you a controlled company. The problem is, number one, coming up with that percentage. Is it 20%? Is it 30%? Is it 40%? Is it 50%? That's a challenge. The second challenge is what kind of governance agreement is going to be satisfactory to deprive that person of control and to make that company
not a controlled company. So those are challenging issues. I don't think they're insuperable, and I actually think that the subjective tests that we've now resorted to, that we've heard discussed, and everybody has a different interpretation of the subjective tests, are really problematic, and they create a situation where an aggressive director, a rich director, a mean director who might retaliate, a charismatic director may be deemed to be in control and thereby subject the company to this whole regime. And I don't think that that's necessarily where the law should be. The second issue is what kind of transaction is covered by this doctrine. So for sure, freeze-out transactions have always been covered by this doctrine. It makes a lot of sense. If you think of it, in a freeze-out transaction, the controlling shareholder is buying your stock, is forcing you to sell your stock in a merger transaction at a price that, if you don't have any judicial control over it, is a price designated by that controlling shareholder. And that would really be chilling to the capital markets. Who would invest in a company that had a controlling shareholder and run the risk of being frozen out of their stock at a price designated by the controlling shareholder? But are other transactions controlled transactions? Is buying director and officer insurance a controlled transaction? We all know director and officer insurance insures the directors, but it also ensures that there's going to be directors of that company. It attracts strong directors, and there's a real argument that I find persuasive that it's in the interests of the company, is compensation. So Daniel talked about the sense of the Musk compensation. I have no idea whether it's sensible or not. I can never understand what the compensation consultants are saying. It always seems to support compensating the executives fairly significantly, you might say. But compensating executives is not the same as a freeze-out transaction. In a freeze-out transaction, there are two sides. In compensating an executive, you're trying to keep the executive, you're trying to incentivize the executive, and these are complex issues that I don't think are susceptible to the control transaction analysis. Is locating the company's executive offices a control transaction? There's plenty of research that indicates that companies tend to locate their executive offices within a relatively close radius to where the executives live. Is it an accident that a lot of executives live in Greenwich and a lot of companies are located in Fairfield County? It turns out it's not. But does that mean that you need a special committee to decide that? And I don't think so. I just think that we're beginning to cover too much in the type of transactions. And the third related issue is the Delaware courts have, I think, sensibly adopted a fundamental rule of judicial restraint over the years. That rule of judicial restraint is the business judgment rule. The Delaware courts don't second-guess business judgments made by a board of directors. So a board of directors may make a really dumb decision, but if they did it carefully, if they did it in good faith, if they did it with enough information and they were loyal, they weren't conflicted, the Delaware courts aren't going to second guess that. The problem with the solution to all of this is that if all of these issues are then subject, if we have a subjective definition of a controlling shareholder, if you have a broad definition of what transactions are controlled transactions, you then end up basically forgetting about this rule of judicial restraint, and you have everything subject to a fairly complex entire fairness litigation, which I think is not ideal. So my view is that the Delaware courts ought to kind of pull back and be a little bit more limited and I think more predictable in how they define a controlling shareholder. I think they ought to be significantly more limited in what they define as a controlled transaction. Not everything is a controlled transaction. Not everybody is a controlled shareholder. And I think then we can get back to having transactions that should be subject to the business judgment rule subject to that.
Thank you. Mark, would you like to discuss the issue of control through contracts?
Yeah, sure. First, just listening to everyone, I just want to make an observation. I don't want anyone walking out of here thinking you have 5 Delaware practitioners and academics and everyone's got a gripe and Delaware is a disaster. I mean, put it in perspective. Investors are willing to put their money in controlled companies in Delaware because while Delaware is not perfect, it's fairly reliable that you're going to get some protections. There are countries where smart investors are very hesitant to put their money in controlled companies because you have no protections. The question is Delaware getting the balance? So now let's get to Moelis and the amendment and my view, which is that really the aftermath of Moelis may fundamentally shift where the Delaware pendulum was moving. First, Moelis, very quickly for anyone who doesn't know, it's actually a pretty simple case. Vice Chancellor Laster had to decide whether a contractual agreement made between Moelis and Company and its founder, Ken Moelis, was enforceable. The question, I'll turn this on. The question was, the contract effectively transferred to Ken Moelis, positive or negative influence or control over effectively every meaningful board decision, even as his economic control would go below 50%, below 30, 40, I think down to 5%. He still effectively displaced the board under this agreement. Vice Chancellor Laster says under Section 141 of the DGCL, the management of the business and affairs of a corporation must lie with the board, and therefore the contract's invalid. Okay. A few months later, we have the statutory change. The DGCL added was amended to add Section 122.18, which effectively says anything in a stockholder agreement with some pretty much irrelevant exceptions is statutorily valid, even if it does functionally divest the board of decision-making power. It preserves fiduciary duty review. So why do I think that the pendulum of Delaware law, which kind of ebbs and flows, the response to Moelis, the amendment, may actually profoundly change where I think the pendulum was moving. So let's move back. In order to see where Moelis and Section 122.18 fit historically on where the pendulum was moving before them, let's move back in time. One end, I would say, is the Martha Stewart case, where the Delaware Supreme Court effectively said that someone with 94% voting power nevertheless did not control the board. And now the court did, I think, a pretty nuanced review of the directors, was realistic and said, look, just because someone's at a 700-person wedding of Martha Stewart's child doesn't mean that they're lacking in independence, but found that Martha Stewart did not control that company. So you have the pendulum at one end. You have cases that follow because there were people who read that opinion and say, I'm not sure how much nuance there was in that. It seems like this black and white rule, and we're really not looking at non-financial considerations. And so you had some applications of some decisions that someone's not a controller of a board or of a company that may have tested common sense, let's say. You then get, a couple years later, the Sanchez case. Call that the case that maybe moved the pendulum in the other direction. Supreme Court takes a look, and instead of following Martha Stewart directly, but without overruling it, they also took a nuanced, thoughtful look at family relationships, found that a 30-plus year close relationship between the alleged controller and the alleged non-independent director was enough to make him non-independent. That basically sent the message to the court, okay, you know what, let's take this holistic view. Let's look at other issues besides just the finances. And you've had that flow to a point where, yes, you have now some opinions saying effectively at a 20, 22% shareholder with certain plus factors, which we could talk about, can be a controller, okay? That process, as you can see with the kind of discontent, really made people say this is too much, the court's gone too far, we need to pull the law back. And this pendulum has been moving back, and I predict at the time Moelis was argued would have been moving back to maybe something, hopefully not a black and white rule at 40%, but maybe something, hopefully something that would leave the court with discretion, but say like, look, if you're below 40%, 35%, maybe there's a presumption that the person's not a controller, and you have a burden to show to get that person who's below 35 or 40% to still be a controller. That's where we were going to. And then you got Moelis. Well, let's look at another aspect of the historical line that led to Moelis and the consideration of that contract, because it becomes important. Why is it okay if the controller law has a trigger at the 35, 40% level, again, with exceptions that courts could find in special situations? It's because Delaware historically had a very strong board. It's board-centric. Section 141 left management in the hands of the board. And the Supreme Court has vindicated that over and over. Go back to the 90s. You had, frankly, lots of companies, advised by many good lawyers, adopt something called a dead hand poison pill. Eventually, after the practice became fairly common, in fact, there was a stockholder challenge, facial challenge to the validity of this pill on a clear day. The court took it up, didn't ask about ripeness. The Supreme Court said, this is invalid because a sitting board cannot issue a rights plan that divests that board or future boards of its Section 141 power. Now fast forward a couple more years. You have the CA versus AFSCME case. Shareholders now try to propose a bylaw that would force a company just to pay back proxy expenses. When the question came to the Delaware Supreme Court, the Supreme Court again vindicated the board-centric philosophy that is Delaware law. And it said, even if the shareholders by a majority approve a bylaw, it cannot divest the board of its decision-making authority and judgment to pay back proxy expenses because they have to be able to consider the facts and circumstances at play. So I think that against the backdrop of Carmody invalidating dead hand pills and AFSCME invalidating a stockholder-approved bylaw, because they take away director discretion, maybe Moelis should not have shocked anybody, okay? Now, the implication of that, though, is as long as Delaware sticks to its board-centric view, the 40%, 35% rule that I think is where the law may have been heading wouldn't be that crazy, because in the end, the power of a shareholder is not to micromanage the board day to day. The power of a shareholder is if you don't like how the board exercises its Section 141 power, you vote them out. That's the power of a shareholder. Yet Vice Chancellor Laster's opinion enraged, upset the apple cart, made a lot of people in the corporate bar very upset, and very quickly we have a rewrite of the law. We have this Section 122.18. Now think about it. Now Section 122.18 allows a board to agree with any stockholder, even a prospective stockholder under the statute, to transfer their future judgment and discretion, notwithstanding Section 141, and notwithstanding whether the person that they originally contracted with had 90% of voting power, but then sells down to perhaps 5%. So I think against that backdrop, you had the pendulum swinging one way to a more strict application like we're hearing from everyone on the panel. But how can a court apply a stricter rule to define a controlling shareholder in a world where now stockholder agreements are where the control is really going to come from? And I think the courts are going to have to take that into account and not apply a black and white rule. So we're going to be left with this messier analysis. Or what's going to happen is this. Before people overreach with their stockholder agreements, before they say that just because the statute allows me to take almost anything I can get out of the board, they might think twice, because I think the stockholder agreement may be the new wild card in creating control, including at levels that might be well below 22%.
Thank you, Mark. So if we take, I just want to add to one issue that didn't come up through the discussion of the panel. If we take the questions that the issue is raising, so the first question, which I think got covered in different aspects, is how do we define the controlling owner? The second question, which is what do we describe as self-dealing? So it got some reference in the discussion, but there is another aspect of it which I think also shows expansion of the reach of Delaware, which is originally we would think in terms of transactions. Okay, so the controlling owner needs to be on the other side of the transaction. That's self-dealing. But then we move to actions, where the company is taking an action. The action has an equal legal effect on everyone, but different economic consequences for the controlling owners and others. And now the question is whether this difference in economic effect qualifies as something that was taken to the detriment and exclusion of the minority, and we can call it self-dealing. So even there, Delaware made the shifts. It started when Google settled the switch from dual class to triple class, and Leo Strine in the settlement mentioned that expectations are relevant, even though they were not legal expectations. But then it moved there, and now we see the case in front of the Supreme Court, which is about reincorporation from Delaware to Nevada, which is an action, being part of the issue of self-dealing. So after the self-dealing definition, the second expansion, then cleansing mechanism. It's already been discussed, and just as Jacobs mentioned, originally people believed that dual cleansing mechanism, like the MFW requirements, would only apply to freeze-outs, and Match came in and say, no, it's across the board. So another expansion. And the point I want to add in this, even the question about how do we evaluate whether a company actually met the cleansing mechanism? And that point, I think, also got a twist, which in a way is expanding the reach of Delaware doctrine. So originally, we had two independent cleansing mechanisms. One, special committee, the other, majority of minority vote. You could pick each one that you wanted and go through that, and you would get entire fairness with the shift of the burden. Whether it's important, it's valuable or not, I'm leaving it aside for a moment. But you could get that. Whatever the value that you get from the shift of the burden, if you picked one, you would get it. Now, MFW was considered to be a concession. It was a concession both for the court and for the defendant. Why? For the defendant, it would allow to avoid discovery and full-blown trial and get the motion to dismiss. And for the court, as Vice Chancellor Will said earlier, they don't want to go through valuation. So you would avoid the valuation, and the defendant will get the benefit of the motion to dismiss. But in order to allow the motion to dismiss to be successful, they have lowered the standard in which we judge whether the special committee functioned well or not. And the standard is basically gross negligence. Then, to make it easier to get the motion to dismiss, then Leo Strine left the court, and cases start coming up. And when you start reviewing how special committees work, and the standard is gross negligence, sometimes it's a not nice sight. You know, it doesn't look very nice when this is the standard. So the court could have said, okay, gross negligence is just too much. We will increase it. Let's make it negligence, or whatever level you want. But instead of doing that, they say, oh, you still confirm, you're perfectly fine on the standard that we applied to you, but the flaws that we discovered now in trial were not disclosed to the shareholders at the beginning, and therefore now the shareholder vote is invalidated. And what will happen is that they tie together two independent cleansing mechanisms and makes it harder to comply with both. So in the last 5 years, out of 15 attempts to go with MFW, only 4 were successful, which tells you that now you might be better off just stick with one and get the shift of the burden instead of trying to go with both and then losing both of them. So that's another shift that I wanted to point in addition to what the panel discussed. Let me now just follow up with a few questions with you, if you don't mind. So Justice Jacobs, how would you view the recent development of Delaware on the effect on litigation costs?
Well, I think I've, in my introductory remarks, addressed that problem. I do want to say that I can't quarrel with Professor Goshen's analysis of how this problem is developed. And I'd like to take it forward for a moment because I have a proposal for a fix. I have to say that my proposal is biased, by 29 years of judicial experience, but it's also biased in favor of clients, not plaintiffs, but clients and lawyers who defend them. The basic simplifying proposition is you don't complicate cases, you simplify them and don't decide any more issues than you have to. Number two,
For anyone who's reading 150-page opinions, we applaud that suggestion.
okay, if you don't do that, then you are basically imposing on your client a lot of grief and a lot of expense. And I think the convolutions of the discussion that we've heard in the last 45 or 50 minutes, if that doesn't convince you how complicated this subject is, I don't know what will. And it doesn't have to be that complicated. The fix that I propose really would require going back to the past, and that is to Sterling versus Mayflower, 1952, and particularly Sinclair versus Levy in 1971. These were all freeze-out merger cases. And the law was very clear. And keep in mind, the problem here, what drives all of this is entire fairness review and the cost and the risk. The courts held way back then, in the context of freeze-out mergers, that there is no breach of fiduciary duty, not even a claim that is governed by entire fairness review, unless the controller actually exercises the control and obtains a benefit for itself and to the exclusion of the minority stockholders. It doesn't matter how you define control. You can assume control. It doesn't matter, whether it's actual control or soft control. You can forget all those issues. There's one thing you have to decide. Was that control exercised? Well, that's the problem. And I, credit Professor Goshen. What happened was that, as the Delaware jurisprudence expanded, the entire fairness review was also expanded to transactions that had nothing to do and went way beyond freeze-out mergers. And that created a problem because what happened is, and I can only analogize this to the entropy rule in fundamental physics, and that is that, unless acted upon by a superior force, every system starts to develop entropy. The order disappears, and I think that happened as in the corporate legal landscape. The constraint of requiring actual exercise of control just somehow magically vanished, and we've gotten into this never land. Where entire fairness review is not constrained by the basic rule that gave birth to it. So my proposal is that we need, if we're going to extend entire fairness review to a greater universe, then let's retain, the logic and the constraint that governed it in the first place, going all the way back to the 1950s.
Mark, follow-up question on that same question about how do you view the litigation cost and the balance that Delaware needs to strike?
I think that, again, I kind of say we're a small part of the world here, and we all read the cases and we focus on litigation, but let's remember the merger world, and even broader, the corporate transaction world, we're talking about trillions and trillions of dollars. And so sometimes I feel like we can easily get overly obsessed with litigation costs. Now, there are litigation costs. There are agency costs that can sometimes be significant, the representative litigation context, frankly, but if you add up all of the wasteful payments, forget good fees paid to, whether it's plaintiffs' lawyers who actually bring a good case and achieve something, all of the fees paid, I guess even including all fees paid to plaintiffs' lawyers, all fees paid to defense lawyers, add it all up, it's a drop in the bucket of the overall corporate transaction world. So I think what I would be driven by is how do we manage those agency costs so they're not wasteful? And that's very simple. How do you do that? Okay, instead of changing the law, it's, hey, we're human beings. We do what we're paid to do, typically. Okay, sometimes we're irrational, but most of the time, you adjust the way fees are paid, you manage the way fees are paid, and you think about the incentives that are being set. You can deter bad litigation, and you can reward good litigation, and then you're managing litigation costs. Now, some of those costs are inevitable, because if you have entire fairness, even the good lawyers on both sides are going to slug it out as, you know, Dan and I would for years, right? We'd have fun doing it, and there was expense to that. I think there is a way to manage the scope of entire fairness without hurting Delaware law, because I think one of the, like I started with, one of the good features of Delaware law is it does recognize that there are certain people, whatever your definition of controller is, there are certain people who have the ability to extract private benefits of control, and whether it's a freeze out or other transactions, you know, like dividends or a repurchase plan or whatever, that they are doing it because of their personal benefit that's different from the shareholders, it's okay, and I would say beneficial, for the court to allow itself to kick the tires. Similar to unical review that we have, you know, in the takeover context. There should be a system where the court can at least check to see, is this benign or is this malignant? And I think the answer on entire fairness, to really manage, not just, you know, manage agency costs with fee structures, but manage overall litigation costs, would be to go away from the premise that says once something's entire fairness, it has to go to trial. I think the reality of the Delaware judges for years, and not just the sitting judges, going back to when I was clerking and you were a vice chancellor, the judges wouldn't really, you know, entire fairness isn't that scary. They wouldn't really rule for the plaintiffs unless there was, you know, a dead body somewhere, okay? It had to be pretty bad to get there most of the time. And I think that if judges are told, even if it's entire fairness, if you can conclude at summary judgment or even before, this doesn't smell bad enough, it's not going to get me to the level where I would ever realistically rule for the plaintiffs, you can end the case there. So now you have the holistic benefit of judicial review, not encouraging wasteful litigation, because the judges now are being trusted to cut off cases when there's a good reason to say, I'm not going to find this to be unfair, and you just trust their discretion. Sometimes you'll have a bad ruling. It's inevitable with any judicial system, but I think that cures a lot of this, you know, worry about too much litigation. It's just give a new tool to the judges.
Thank you. Daniel, why is that we see now a lot of cases involving controlling owners? What's your view on that?
So I think there were two factors which are sort of intertwined. The first is that, like, the prominent corporations in America have changed. Like, when I started practicing law 34 years ago, you know, we represented IBM and Time Warner and Chemical Bank, and they're not controlled, right? But today we represent, you know, Meta and Alphabet and Tesla, and there are these companies where there are individuals who almost certainly have significant shareholding. Some of them are really controlled, like Zuckerberg controls Meta. He has voting rights. But some of them, they just have, you know, soft power, right? They have big personalities. They have the vision. They're the founder. And as the world has changed, the law has changed to say, you know, I'm not that comfortable with that soft power. And so I'm going to include soft power factors in the legal definition of what it means to control. And you put those two together and you have this explosion of cases.
Thank you. Anne, would you like to provide your view following on Mark's initial comments on Moelis?
Yeah, I am, but I do want to jump in on the whole expense thing, because I think we're leaving out something. Now, it's not doctrinally satisfying, but it is still true that the two-trigger MFW requirement is not necessary for the demand in derivative litigation, and we can talk about all the doctrinal oddities and why that is and so forth. But the reality is, it means that if it's a derivative case, it really is, in a way, only single trigger cleansing, because the board, at the board level, because if the board is independent, that case isn't going anywhere. So what that practically means is big cases will go to trial and little cases are going to get dismissed on demand, futility. And I think that's an important part of figuring out whether the expenses fall in the right place. But okay, yeah, so, but the other comment I had was about the effects of SB 313 and 12218. So as already been said, we're going to get much more complicated questions about who is a controller. And it's not even going to be about soft control. It's going to be about bespoke contractual rights. And you're just not quite sure whether they add up to enough to call them a controlling shareholder. And that's going to matter. And I think it matters separately and differently for whether they have fiduciary duties versus whether or not their conflicted transactions need to be cleansed. But another question we're going to have is especially if one of these contracts is entered into after the company's already publicly traded, we'll definitely get a lawsuit. Okay, fine, lawsuit's inevitable. Is that lawsuit going to be direct or derivative? That's going to be a really important question. It's going to be a really important question in terms of whether or not the demand requirement is enough to get rid of it. But another thing that I'll add, and this was mentioned on the previous panel, those stockholder agreements might have arbitration clauses or forum selection clauses, and it's very possible, especially if it turns out that there's a challenge that's brought derivatively, it's very possible that these kinds of disputes are not going to be heard in Delaware. They might be heard in secret arbitration, they might be heard in another court. But one thing that the other panel said that I disagree with is it's necessarily Delaware law. I don't think it's necessarily Delaware law. Shareholder agreements do not have to be governed by Delaware law. There was a recent Delaware case, the Palantir case, Books and Records case. It was about a shareholder agreement governed by California law for a Delaware company. This happens all the time. So the questions about what to do about abusive controllers, however you define abusive, they aren't necessarily going to be decided in a Delaware court, and they're not even necessarily going to be decided under Delaware law, which is when it's going to get very strange.
Stephen, would you like to expand whether shareholder agreements now might be the solution to the issue of controlling owners, and your view about how we should think about the cleansing mechanism?
Yeah, all right. Let me make first a preliminary observation, and that is this panel is really discussing conflicts of interest. And so you see a bunch of lawyers talking about legal fees, and not shockingly, we all think that that's not such a bad thing. In terms of defining who is a controller, I think these governance agreements are really important. And some of them in Moelis, for example, made it perfectly clear that Moelis was the controller. A lot of these agreements that are used in settling activist efforts are ones that really limit the control of the activist. And there's plenty of these cooperation agreements dealing with really big stockholders that limit the power of the big stockholder. And under those circumstances, I would say that a transaction with those big stockholders is not a control transaction because the agreement limits their ability to control. Now, a related point to all of this is what should be the cleansing mechanism. Right now, the cleansing mechanism is a really good special committee and majority of a minority approval. I would do two things. Number one, I think courts are actually very good at evaluating process, and I think courts should enhance their review of the quality of the special committee's work. It should enhance the review of the independence of the special committee, the functioning of the special committee, and whether it really did negotiate hard. I think that's the first step. The second step, I think, is even more controversial, and that is that I think that the majority of the minority approval is really a mistake. I think that in any transaction other than a freeze-out, you're creating a shareholder approval requirement that doesn't exist under corporate law. And I'm going to tell you, as a corporate lawyer, I have no idea what goes into the proxy statement. I don't have line items the way I do with an annual meeting or a special meeting. I've got to decide what goes in that proxy statement, which is a challenge. The second point is that we now have index funds that control about 20% of each public company in the United States, and that percentage is going up. And if people think that their vote one way or the other is especially meaningful in this cleansing process, I'm not going to agree with you. The third thing is that we have a lot of stock these days that are held as hedges under derivative contracts. And financial institutions typically will not vote those shares. So you've got kind of a shrinking base, you've got a lot of stock held by index funds, and you have a long history of these things being approved. So the question is, why do it? And I would say I would enhance the functioning of the special committee, and I would get rid of the second prong.
So before I open up for questions from the audience, I see here the General Counsel for Moelis. And maybe he would like to come and tell us a bit about how the contract was born. Can you come to the mic, please?
So we filed an appeal, so I don't feel comfortable talking about it.
All right. So.
You need to share it.
Okay. Okay. So questions from the audience? Anyone? Can you come to the mic, please?
Hello. So Mark, you brought up KKR with the Vice Chancellor. And the example there was KKR had 1% of the entity, but a management services agreement. But the Delaware Supreme Court found there was no control. I think this is an inconsistency in the law here, because if you have a multi-class company, the charter is a contract which defines the classes, and you can have, for example, Class B, I hold 1 of 1 shares. I have 1% of the economic rights, but I have full control of the company through the voting rights. So why is one contract different from another?
It's a very good question.
Can you turn on the mic?
I'll turn it on. I'll turn it on. It's a really good question. Now in KKR there weren't 2 classes, so they actually had like 1% of the voting power. Back then, back when Delaware pre-12218 really was board centric, there were two ways that case was presented. One was its entire fairness because they have control. One was they've sold control and it's a Revlon transaction. The court kind of shooed away the Revlon argument, which I would submit really was the more logical one under the law at the time, even though I was one of the plaintiffs lawyers on it. I thought that would win. The entire fairness was a reach because they only had 1% of the vote. And back then in the board-centric model, you had the court and the law say the board is the supreme power in a company unless someone actually has voting power or voting power and other criteria that really get you there. We tried to take it would have been the tiniest amount, right? It was 1% or less than 1%. KKR structured it on purpose, right? It was strategically done.
Yeah. And they didn't dominate the board.
They did not dominate the board. And what the court says is you
really
can, you have 1%, you have absolute managerial control day to day. You have a huge payout if, a lot of things happen that you don't like if the board somehow rebels. Yet, you can complain to the board, but it's the shareholders that decide who the board will be. They're going to vote, and if that board caters to KKR, presumably the shareholders could have used their voting power. Again, that's because the board was the supreme power, and that contract was viewed in the context of a company that actually had independent directors and the ability to make every day-to-day decision. I think the difference that we're talking about is, essentially post-12218, you can't really challenge the contract with Moelis, and you're going to have, look, I guess if someone did a KKR deal now, could someone say KKR is a controller?
Well, so the tension there, and it's what Professor Lipton brought up, is when you're thinking of control, you want to think about it situationally specific control rather than just general control. But if this threshold inquiry is, can you appoint and remove directors, then you'll never get control with the contractual rights only.
Well, Moelis had that.
I think the theory, which is what sort of makes loan agreements acceptable and employment agreements acceptable, I think the theory is that the board can breach the contract and pay financial damages for it, and that really is the solution to that problem. Now, it may not make a lot of sense if the damages are prohibitive, the damages make the company go bankrupt, but I think that must be the theoretical basis for saying that as long as the board is not controlled, But if in the KKR situation, if they had a majority of the board, you have no doubt.
If they didn't have a majority of the board.
But there's no doubt that if they did, if the contract provided you own 1% of the stock, you have the right to manage, and a majority of the directors are appointed by you, there's no chance KKR wins.
No, that's right. And Steve just kind of referenced something that Professor Talley said when he was with Vice Chancellor Will, the liquidated damages clause in a stockholder agreement. I actually think that if you're negotiating an agreement like this, and I would be afraid that a judge would, I'd say rightfully say, I'm a controller if I take too many powers. I mean, Moelis had everything. So I assume a lot of these stockholder agreements are much lesser, right? There's a much lesser transfer of power than the Moelis agreement itself. But maybe one way to protect yourself from being deemed a controller is to essentially provide a path for the board to disagree with you. Because I don't think boards are going to breach when they don't know what's going to happen. But if you know it's $10 million or $50 million, it's like a termination fee of the agreement. Maybe that's a way to avoid becoming a controller through the stockholder agreement.
Thank you, Mark. And unfortunately, we are out of time. Please join me in thanking our panel.